Good morning, and thank you for joining us for this week's weekly Wednesday presentation regarding healthcare proxies and power of attorneys provided by the Legal Aid Society of Mid-New York. This presentation is being recorded and will be uploaded to the Otsego County Office for the Aging Facebook page and to our county website. I ask that everyone except the presenter and myself keep your videos turned off and that you remain muted unless you have a question. Please feel free to unmute yourself and ask those questions as we move through the presentation, or you can also use the chat feature if you prefer, and I will ask the question for you. For those who are new to Wednesday presentations, we host presentations every Wednesday using the same link at 11 a.m. Topics are on various community-based organizations, services, and programs among Otsego County. This was established in October of 2020 as a way to continue education on services and supports amid a global pandemic. For those who do not know me, my name is Alicia Chase. I am Otsego County's long-term care coordinator. My role here at Office for the Aging is to supervise the New York Connects program, which provides information and assistance on all long-term services and supports available in the county. Although my office is under Office for the Aging, we are unique in that we are able to help anyone of any age who is looking for help navigating the complicated long-term care systems. We can assist those who just want information and assistance, need referrals to other community-based organizations such as the Department of Social Services, Mental Health, Catskill Center for Independence, Resource Network, Family Resource Network, and interagency referrals here at Office for the Aging. We also refer to Adult Protective Services and Social Security. If you need help with applications, caseworkers from New York Connects can assist you with that. We can also help people seeking admission information for adult homes and nursing home placement. If you're unsure if New York Connects can help you or your loved one, please do not hesitate to reach out. We do have a New York Connects partner, Vince Baker, with the Independent Living Center in Oneonta. For those wishing to reach out to me, you can do so by calling Otsego County Office for the Aging at 547-4232. At this time, I'm going to turn the program over to Alice Decker with the Legal Aid Society for today's presentation.
Good morning, everybody. I am Alice Decker. I'm a managing attorney at the Legal Aid Society of Mid-New York, and I currently work out of the Oneonta office here in Otsego County. We provide a variety of legal services to people of all ages, mostly low income, but not exclusively so. At the end of the presentation, I will give you out the helpline telephone number, which is an 877 number that anyone can call if they have a civil legal problem and they're seeking assistance. And the intake specialist will walk everyone, through the intake process, determine whether they're eligible for services, and then route them in the correct direction if they are. So please do feel free to ask questions as we go along. Because of the format, we'll try not to sort of step on each other as we go. And sometimes I think the chat function is really helpful for that. And Alicia has graciously said that she'll keep track of the chat and she'll read those out as we go along. But if you just want to unmute yourself and ask a question, that's fine. If you want to ask a question verbally, this kind of has two separate parts, so I'll pause in between the two parts and ask if there are any questions at that point before proceeding on to the second half. So as you can see, I'm going to pull this up into a full presentation here. This is entitled Planning for the Future, Powers of Attorney and Healthcare Proxies. This is part of a presentation that I've done in the past, which also included wills. We're doing wills next month. So if you want to come back for that, we will be here. This really is the basics of what's going on in New York with these two advanced directives. More complicated questions, I may be able to touch on a few things, but at that point, we may need to schedule appointments or reach out for technical assistance if you are a service provider. Okay, let me actually minimize people here so I can actually see my screen. Okay, so it's always good to know that these presentations are not meant to be a full explanation of the law. Like I said, this is about basics. It's also not a substitute for meeting with an attorney to discuss every individual situation. A lot of people have similar situations, but there are unique elements to all of it, and speaking to an attorney to make sure that you have a plan that works for you or your loved one is really the best way to go. So let's start with powers of attorney. It's always good to learn vocabulary as we go along. The law, like many things, has its own language. So the principal is the person who's entering into the power of attorney. They are the one coming to the attorney and saying, help me, I wish to do this. I need to name this person as the agent, or sometimes called the attorney in fact, but I'll refer to them as the agent throughout this. That is the person that the principal names and assigns powers in the power of attorney. Power is simply the ability or the right to do something, and we can talk about a couple of those as we go along. A successor agent is a person who would act if the agent is unavailable, if they pass away, if they're on a vacation, and those sorts of things. So if the agent cannot or will not act, then that successor agent can take over. An extremely important concept to powers of attorney and healthcare proxies is that of fiduciary duty. This is defined as the responsibility of the agent to act in the best interest of the principal and avoid any conflicts of interest, particularly in the area of self-dealing. Self-dealing would be if an agent enriched themselves at the expense of the principal. And this can happen, and it's one of the reasons that we have other programs available in the state for things like exploitation of elders, in the financial realm. Particularly, although obviously there can also be other kinds of abuse and neglect that go on in these situations. It's also important to understand that if the principal continues to be competent, they are fully still capable of making their own decisions, directing people, the agent and others to do things. You do not give up your right as the principal to act on your own behalf simply because you sign a power of attorney. And if the principal is in fact competent and capable of directing others, if that other happens to be the agent, they must act in accordance with the direction or the wishes of the principal. And a failure to do so is a violation of their fiduciary duty. It is really the core element of what goes on with these advanced directives, particularly the power of attorney, when an agent is named. Generally speaking, there are three types of powers of attorney. The one that most people end up with in this sort of circumstance is what's called a general durable power of attorney. General just means it has broad application. Durable means that it takes effect immediately and stays in effect even if the principal suffers a disability, such as a dementia or a comatose state later on in life. Most people, when they come to the Legal Aid Society and are thinking about getting a power of attorney, this is the kind of power of attorney that they want because they are planning for the future. They're saying, I'm okay now, or I've just been told that I, have Alzheimer's. I want to prepare for the future and get this power of attorney in place in case my situation deteriorates or because I know my situation will deteriorate. And so in order to, if this power of attorney just stopped being effective when the principal was no longer competent, it would not actually affect that purpose. So the durable type takes effect immediately, stays in effect until it's either revoked by the principal, so long as the principal still has competency to do that, or until the principal dies, and we'll talk about that a little bit later. A non-durable power of attorney takes effect immediately, but then it expires after a specific event occurs. It can be after a certain date. Sometimes people sign real estate powers of attorney to, empower, say, an attorney at law, rather than an attorney at fact, an attorney at law to act on their behalf in terms of negotiating and signing contracts and those sorts of things. These tend to be relatively short term and for a very specific purpose. I mentioned vacations for the agent. Well, if the principal goes on a vacation, isn't going to be available, they may need to have one of these in place so that someone can handle their business affairs and that sort of thing. A springing power of attorney takes effect upon the happening of some kind of event in the future, and that can be such as dementia or a comatose state. These are very sort of picky little documents. We do not do these at the Legal Aid Society because they are not considered simple planning tools. If you're really thinking about this sort of thing, you should see an attorney who specializes in more complex estate planning and advanced directives type of practice. Okay, so I've been an attorney since 2005, and in the time that I've been an attorney, we are now going into our third iteration of the law of the power of attorney. So it sometimes seems like every time we turn around, it's changing. So the law that's in effect right now was passed in 2009 and it took effect in 2010. Before that point, New York's short form was what it was called, was a simple document, required the signature of the principal and the attestation of the notary public to create any power that the principal wanted to create in the agent. Excuse me. After the 2009 law went into effect, the principal and the agent both had to sign before a notary public, and to create some of the powers, witnesses were also required. So things got a bit more complicated. One of the reasons that the legislature decided they wanted to do this was to protect principals from potentially bad acting agents. And there was specific language that was required both as, I think it's entitled caution to the principal and information to the agent. And that language required to be in all powers of attorney that, at least alleged to be these statutory powers of attorney. Generally speaking, I think that information was very good, and it will continue because we're going to talk about a new law that's coming up soon. But it did create some issues. I do want to stress that if you have a power of attorney that was enacted, like I said, the law was in 2009, it actually took effect in 2010. So before the current law went into effect, so you have an old one, it's still valid. You may want to think about updating that and talking to an attorney. If you take a look at your power of attorney and you're like, gee, this person doesn't even live near me anymore, or gee, I don't know why I selected that particular item for my agent to have power. I disagree with that now. But if you don't disagree with it at all and it's still working for you, then there's no reason to change it. Okay, so here's history part 2. So our new power of attorney law will take effect June 13th of this year, so just short of a month from now. There are many technical and non-technical changes. So when I talk about a technical change, what I mean is that it's really stuff that's targeted at the execution of the document, the signing of it, who has to be present, and who has to sign, and those sorts of things. Lots of stuff for people called third parties who will be accepting, hopefully, the order, the power of attorney, and those are quite deep and interesting changes that are being proposed. Well, not proposed, it's the law now. And then non-technical changes, the things that actually affect your life. And so there's just some crossover between those two things. So as of June 13th, when this law changes, if you have a power of attorney that you entered into before that date, but after the old law, so then we have the old law, the current law, and the new law, that will still be effective. One of the issues and one of the reasons that the legislature decided to tinker with this yet again was because there was a requirement in the current law that the language in the power of attorney must be strictly complied with. And if there were little errors in that language, it could invalidate the entire document. I don't know why courts would do that, but they did. So the legislature stepped in, and one of the technical changes that they made was, rather than have the language strictly complied with, it now only needs to be substantially complied with. So if there are little deviations, if something is spelled wrong, if if an address is slightly wrong in the document, it's not going to invalidate the entire thing. So that's a positive change. So let's talk about some of the other changes. In the current power of attorney, if any of you have one, have seen one, have relatives who have one, you know that there's a section where there's a bunch of powers, items that are listed out with little lines next to them where the principal can initial. And one of those is a gifting power. The current law has a gifting power that the agent can gift up to $500 per year. For some reason, the legislature thought that was not enough money in the power of attorney proper, and now this order I'm sorry, my brain is in another place. Powers of attorney. This power of attorney, the gifting limit is now up to $5,000 per year. If we have an elder who is of modest means, and we have an agent who doesn't have the best of intentions, that gifting power of $5,000 could potentially wipe them out. So I'm not sure how I'm feeling about this change for people who have a relatively lot of assets and liquid assets like bank accounts, stock accounts, those sorts of things. That limit would probably, be an okay limit to protect someone. There also is a way to empower the agent to gift more. It used to, in the current law right now, be contained in what's called the statutory or major gift rider, and the principal could empower the agent to gift more within that section. Now that power will still exist, but it will simply be included in a general modifications section. So if the principal has $1 billion and wants the agent to be able to gift to individuals or charities or whatever, up to $1 million a year, they can make that provision within the new power of attorney. In the old days, the pre-2010 days, the only thing that you needed to have done to execute your power of attorney was that the principal appeared with their identification in front of a notary public, signed, and the notary acknowledged their signature. In the current law, that is still true. However, as I noted before, the agent must also sign in front of a notary public in order for them to be able to act. And in order for that major or statutory gifts rider to take effect, they also needed to have 2 witnesses to do that. With this revamping of the law, the signing of the power of attorney in its entirety will require 2 witnesses. However, one of them can also be the notary who's going to notarize the principal's signature. And, if you go to an attorney's office and you do this, usually one of their staff will, or 2 of their staff will step in and be the witnesses, and then there'll be a separate notary. But we have this very small office here in Oneonta, and with COVID going on, we don't have full complements of staff in the office every day. So it's actually pretty handy for us to be able to have 2 witnesses. The attorney can act as a notary, and there just needs to be 1 more witness. So that's, so if they're going to have this witness requirement, at least it appears to be manageable for even small attorneys' offices to do. One thing that's important to remember is that if one of the witnesses is going to be someone that the principal knows, it can't be someone who is actually going to be an agent under the power of attorney. So it has to be a disinterested party. That's very much like will signing. The people who witness wills can't be someone who take under the will. So this is very similar. And some of these changes really have been enacted to kind of try and line up some of these things in conjunction with the way wills are. A new provision is a requirement now that the agent must keep a record, meaning just a written log, or all the receipts or payments and transactions that they undertake on behalf of the principal. In the past, it was recommended to do this because the principal has a right to, for an accounting at any time if they suspect that something's going on or they just want to keep on top of their business. And so it was recommended that agents do this, but there wasn't really a requirement. Now there is a requirement. So if you are going to be an agent, or if you're talking to someone about being your agent, it is really a good idea to make sure that you or the person you're talking to understand what their requirements will be. This is not one of those things that can just be sloughed off. A failure to do this could lead to really serious repercussions down the line if there are allegations that money was misused or assets were conveyed without consent or not in the best interest of the principal, et cetera. So keeping track of all of this stuff has always been a good idea, and now it's a requirement. One of the parts of the new law that potentially I think is the most problematic is this process by which a third party, so again, the third party is the person who the agent is going to ask to honor the power of attorney. So they're going to go into the bank with the power of attorney and say to the third party, bank official, I am the agent for so-and-so, and here's my power of attorney, and I want to do X. So the process by which the third party can challenge the validity of the power of attorney can be something that's annoying or even potentially expensive to the principal. And so attorneys are being recommended or advised to make sure that they make this part of the conversation that they have with their clients who are contemplating doing powers of attorney. Part of this process requires that the principal may have to give an affidavit to the third party attesting to the validity of this document, or even securing counsel's opinion. And the principal would have to pay for that. Counsel's opinion is a lawyer's opinion about the validity of this POA. Things that are a little bit more positive about this is that it does force the third party to act. They can't just sit on it and do nothing. The law also presumes, meaning that in the absence of convincing evidence to the contrary, there's a presumption that the power of attorney is valid. One of the problems that occurred over the last bit with the really both iterations of the law, the current one and the old one, is that third parties would just say, well, I'm just not sure about this power of attorney. The signature doesn't look quite right. So I'm not going to honor this. You go have the principal sign our power of attorney, and then we'll talk. The law doesn't allow third parties to do that anymore. So the power of attorney is presumed to be valid. If the third party has problems or concerns, then they have to act, and I believe it's within 10 days, in writing, asserting what they believe is wrong with the power of attorney. And if they don't do that, then they are going to be foreclosed. And if they allege one thing that they think is wrong, but they don't include something else, they're not going to later on be able to say, oh, well, you addressed my concern about the first thing, but now I have this other thing. So they're not going to be able to do that anymore. And that's beneficial for principals and agents because they stop getting the runaround. There are time limits on these things. I'm not going to go into those, but I think it's going to be very, very interesting that that we're going to have these. And every time there's a change in the law, things get a little crunchy. But that's why attorneys are being, like I said, advised to make sure they're having these kinds of conversations with their clients so that they understand. More changes, like I said, there are lots of them. I think one of the most important ones is this next one, which is that the agent can now be a personal representative for healthcare financial matters. In the past, medical hospitals, doctors' offices, dentists' offices, whatever, sometimes gave the agents a real hard time about receiving financial information, like how much is due at the doctor's office, why didn't the copay go through, what's going, and all those sorts of things, because they said, well, that's a HIPAA thing and we can't give you that information because you don't have a HIPAA release. Well, now you have a principal who may not be competent anymore, they can't sign something, and it became a real problem. So the new law really does, hopefully, I think it will, solve that problem and make it very clear that for strictly financial matters in terms of healthcare, the agent is empowered to be the personal representative and receive that information without a HIPAA release. It does not change any of the healthcare decision subject matter that still requires the healthcare proxy, which we'll talk about. That's the second half. We talked already about how the power of attorney must substantially conform with the statutory form rather than strictly conform. However, those sections about caution to the principal, information to the agent, they're still in there and definitely worth a read. These documents got a lot longer in the current form, and that's not going to change a lot in the new law. And it does take a while to read through them, and a good attorney takes the time and lets their client read all the way through the document and ask all the questions that they need to. And I'm just going to stress one more time that one of the things that has not changed is that your agent must still sign the power of attorney before a notary public in order to be able to act. In the pre-2010 law, that was not the case. It is now, and it continues to be in the new law that takes effect in June. I want to mention a couple of miscellaneous sort of topics here. Powers of attorney become ineffective at the moment the principal dies. At that moment, if there is a will, the will springs into effect and then dictates what will happen going forward. But the power of attorney at the moment of the principal's death stops being effective. If the agent uses that power of attorney after the principal has died, it's fraudulent and criminal, and it can carry a sentence of up to 1 year in jail on each charge. So if the agent goes out and uses that 3 times at different banks to move things around or access a safe deposit box or whatever, each one of those things is a separate charge. It can lead up to 1 year in jail or a fine. So it's very important that the agents understand, and they might not even be trying to do something wrong. They might be trying to move funds so that they can pay for a funeral or something like that. But that's planning that should take place ahead of time. Just don't want people to get into trouble when they're trying to be good-hearted about things. So they have to be careful. And again, we talked about how the power of attorney does not permit the agent to make any kind of healthcare decision. In some states, they have something called a healthcare power of attorney. That is not what we call our document in New York. So if you decide you don't want to go see a lawyer and you're going to do this, via one of the internet programs that are available, I don't really recommend it, but if you're going to do it, steer away from those. New York State uses a form document called a healthcare proxy. We're going to talk about those momentarily. And they can take various forms, but there's a real handy one-pager form that's perfectly fine for folks to use. So if you're seeking a healthcare proxy, that's also something that you can speak to your your attorney about, if you say you want to go and do a will, a lot of times attorneys will ask you if you want these other kinds of documents as well. Okay, so before we move on to healthcare proxies, here is the moment where I will pause and let people raise questions that they have.
Anybody has questions, you can go ahead and unmute yourself to ask those, or you can type them into the chat and I'll ask them for you. For those who just joined, we just completed the section on power of attorney and we're going to move on to healthcare proxy shortly. Oh, here's a question. If the person passes away and you're the power of attorney, how do you pay for the funeral? Is it legal to still write out the check to pay the funeral home?
No. So if the funeral is prepaid, then obviously the work has been done ahead of time, right? So that's where we talk about, planning ahead. A lot of times people will designate funds in their life insurance with the intention that those will be used to pay for a funeral. The problem is that sometimes the timing on that doesn't work so well. It takes a while to get the proceeds from the life insurance company, and maybe the funeral home you want to deal with doesn't want to wait for them. So, what's frequently recommended is that you and the principal have had a discussion about, what kind of funeral they want. Some people don't want any kind of funeral at all. Some people want to be cremated rather than interred. So, having those conversations, we're going to talk about that when we talk about healthcare proxies, having uncomfortable conversations, at least for many people, they're uncomfortable, can really save a lot of heartache down the line. So I encourage folks to have them. Prepaying a burial plan is a great idea. A lot of those funds are protected from various things. So if you're in sort of like Medicaid planning mode or those sorts of things, that's a good thing to talk to the attorney about. But if none of that has been done, then, either being a co-owner on a single account is a good idea, or transferring funds as the agent in advance of. Now, obviously, this does not protect against sudden death, but if we're talking about, a sort of a process where someone has been ill for a while, maybe they go to hospice and these sorts of things, then the agent should be, if the agent is also particularly going to be the person who's the executor of a will, which they frequently are, then, they can be thinking about these things sort of in tandem. But it's important to remember, and I'm glad that you raised this question, that power that you had to go into the principal's bank and say, I need to take out $10,000 for the funeral, the principal has died, you no longer have that power. If you are, if you're on that account, then you can go ahead and do that. But it is something that people need to be careful about. Other questions? Okay, if you think of something while we're talking about healthcare proxies, then feel free to type it into the chat and we can circle around at the end. This half is going to, I was just going to say this half is going to be shorter, which would make it not a half. But,
I have one more question for you.
Sure.
They have a document in different states over 31 years, I think over 31 years ago, maybe. They should be meeting with an attorney after June 13th, or should they meet with them anytime?
Theoretically, that document is still effective. I would think, however, if you have a power of attorney that's 31 years old, you at least want to have a conversation with an attorney about it. And because it's from out of state, it doesn't mean it's not effective in New York State. It is. But, there may have been limitations that are in that document because of that state's law that you might not have to abide by in New York. So it's worth having a chat with an attorney about it. Alrighty, here we go. Okay, so now we're going to shift gears a bit, and we're going to talk about healthcare proxies. This is another form of advance directive. And just like with powers of attorney, we're going to talk about vocabulary first, and we see a word that's familiar to us, the principal. The principal is the person who's entering into the healthcare proxy, just like they were the person entering into the power of attorney. Rather than an agent, we have a proxy. That is the person who's named to make decisions about the principal's care. I also want to point out the term living will. A healthcare proxy and a living will are different documents. They do different things. Frequently, they can be married to each other. We actually do a healthcare proxy with living will, so you can marry them together. But theoretically, I like to think of them as separate documents because then it keeps things clear as to which one does what. It's sometimes executed along with the healthcare proxy. And rather than instructing the proxy what to do, it instructs medical personnel what to do. So if you don't have a healthcare proxy or your proxy is not available for some reason, but you've done a living will, then the medical personnel can follow your living will and make sure that your wishes are effective. Okay, so these are more practical or pragmatic concerns in terms of naming your proxy or proxies. You should consider people who, let's start with a person, should be someone who's available quickly in the event of an emergency. While it is true that a proxy certainly may be a relative who's at the hospital at the end stage of disease and those sorts of things, there may also be issues related to sudden onset, accidents, and these sorts of things. And if your proxy is a person who's really hard to get a hold of, that may not be the ideal person to name as your proxy. If you name more than one proxy, consider selecting the primary and then the successor to avoid disagreements. That way, the first person acts, and if they're just not available, then the second person can step in and act. I think it's helpful, again, to have those really potentially awkward or uncomfortable conversations. The story that I always tell, and I will tell it again, is that my mother had 4 children. Our youngest sibling was 8 years younger than he is, 8 years younger than I am, and I'm the second youngest child. And when he finally graduated from high school, my parents had been divorced for a while, and my mother had done her will and her healthcare proxy and her power of attorney and all of this sort of stuff. At his graduation party, because her children were kind of flung all over the country, she brought all of us into the kitchen and told all of us what her new estate plan was. And her friends were horrified. She's like, when am I going to get them all together again? And she made it very clear to us, and my older brother and I were actually the proxies, that, what she wanted and what she did not want. We're a pretty blunt family, so that worked okay for us. But other people may have to ease into this with children or spouses or other relatives or close friends who, don't want to have these difficult conversations, but who would be perfectly willing to help out. It's incredibly important to make sure that you are picking a person who knows what you want and will do what you want. The living will, as opposed to the healthcare proxy, can specify certain conditions be met, and then the medical doctors decide, that those conditions have been met before they act on your wishes. But the healthcare proxy really is about communication. There's some simple boxes to check if you don't want hydration, or you don't want a feeding tube, or you want a DNR, do not resuscitate, and those sorts of things. But it's not very detailed. I mean, it can be made more detailed in the healthcare proxy, but traditionally it relies on the relationship between the principal and the proxy to have had these conversations and understand that they are communicating these really important topics. The healthcare proxy form includes the spaces for telephone numbers to be provided. Do that. And if those numbers change, that is a good reason to update healthcare proxies. Please do not write on your healthcare proxies or any other document that you execute, particularly in the form of wills. We're going to talk about wills next month, but if you write on them, you can invalidate them. It's a really bad idea. But if most times nowadays with cell phones and whatnot, people's numbers don't change even when they move so much. So they kind of stick at this point. It's hard for a medical doctor to rely on a proxy if they don't have a telephone number to get a hold of them. Okay, so how does it all work? The proxy makes a decision for the principal if the principal is unable to make decisions for him or herself. So long as the principal is competent, that if they've been diagnosed with some sort of dementia, but they are perfectly lucid at the time that they're being asked to make a medical choice, they get to make that choice for themselves. The proxy is not involved. However, if there is an incapacity because of dementia that has substantially progressed, or perhaps someone's just been knocked unconscious, at that point, because they cannot make a decision for themselves, then the proxy can be contacted and again express what they want to have done based on what they know the principal's wishes are. So we talked a little bit about the sort of simple guidelines and making sure that those are clear. I sometimes recommend that if, sometimes, a parent will say, I've got this one child who's kind of, a free spirit or whatever, and hard to get a hold of, and I'm not necessarily sure that maybe they'll be sort of in line with what I'm thinking. And I've got this other kid who's like really, really reliable and that sort of thing in most things. But I'm not sure that kid will follow what I want either. It can be a very difficult thing to select a proxy when you don't know if someone will follow your wishes. At that point, you may want to think solely about doing a living will and not doing a healthcare proxy at all. And so here is our, delineation. Physician who has primary care of the principal finds that the principal is no longer competent, and then the proxy can act, right? If there's no proxy available, that's the healthcare proxy, the first part. If there's no proxy available, then the attending medical provider determines that the principal is permanently unable to make decisions, and then the medical professionals will follow the specific instructions. You can see that there's a lot of difference. One is a little bit more temporal and the other is a bit more permanent. That is the end of that. So does anyone have any questions about the healthcare proxy section or circling back around to powers of attorney? Usually get lots of questions.
You can unmute yourself to ask your questions, or you can go ahead and type them in the chat if you have some. Is there a form the primary care needs to complete to show competency?
Usually each medical facility will have its own process, and all of those things will be noted on the patient's chart. It's worth having a conversation with your primary care physician if you're concerned about these things, and certainly if you're going into the hospital or from a hospital to a rehab facility or something like that, to have these conversations. If any of you have ever gone into the hospital for any kind of a procedure, a surgical procedure, et cetera, you'll notice that people show up with these healthcare proxy forms pretty readily. Also, your doctor's office most likely has them available, and so long as they meet the basic requirements, which is that that there are two witnesses to the document, that, you know, it's pretty straightforward. So certainly also have those conversations with your doctors or other medical professionals if you're having these concerns. And, you know, this isn't just for older people. Same thing with powers of attorney. I mean, you can be young and get a power of attorney for some reason. Maybe, you know, maybe you're a thrill-seeking person. You like to jump out of planes or whatever it may be. And you know, you just want to make sure that, you know, if something happens, somebody, you know, has access to, you know, to the nuts and bolts of your life. But most of the time, people don't start thinking about these things until they get older. But having those conversations, both with your family, with your medical providers, you know, if you have a financial planner, you might want to talk to them about what kinds of things it would be a good idea to include or not include in a power of attorney. So there's lots of conversations that can be had.
Are there any other questions? Wow, we got a quiet group today.
I know, usually we have tons of questions. Okay, so I know that Alicia said that she would be happy to make the slides available to anyone who asked them, and that's perfectly fine with me. I do want to give out the helpline telephone number for folks who may want to contact the Legal Aid Society about pretty much anything. Please note that if you are a person 60 years of age or older and residing in Otsego County, then and you wish to have legal aid services, you're going to need to contact the Office of the Aging directly, and then they do a referral to us. If you happen to be a resident of Delaware County and just happen to pop in here, the same rule applies. You need to contact the Delaware County Office for the Aging, and they will make a referral. If you happen to be a resident of either Broome or Shenango counties, those counties do not require referrals, and so you may contact us directly. And I'm going to go ahead and give you our helpline number, and that is 1-877-777-6152. And I can do that again if anybody would like. Going once, going twice. Back to you, Alicia.
All right, so we got a bunch of things. Thank you, very informative, but no questions. So that's all for our presentation today. And next week's presentation is the Aging Life program through Catholic Charities. So you can join us, same link, same time. And that's all we have for today. Thank you for joining us, Alice.